now call MK, Honorable Dr. Hlophe.
Thank you very much, Chairperson. Honorable Minister, Deputy Minister, Honorable Members of Parliament, I see some officials. Good afternoon to all of you. I rise here on behalf of the Umkhonto weSizwe, and our position is very clear. We are vehemently opposed to this budget cut for a number of reasons, including, but not limited to, the following. My contribution is going to focus on the lower courts and particularly criminal trials. The first problem that everybody knows is the following. Lower courts are understaffed and the working conditions are deplorable. Now, a further cut on the budget can only make matters worse. We all know, for example, if you go to the magistrate's court now, where the court is busy, seized with postponements, each magistrate postpones 40 cases per day. I would have thought judicial officers read the files before they postpone them. I have no idea how a magistrate can read 40 cases. This leads to my second point. Section 50, subsection 6 of the Criminal Procedure Act makes the following provision. It provides that a case may be postponed for investigation for a period of up to 7 days. Now, where you are a judicial officer and you have 40 cases per day on your postponement roll, right? What happens every day is the following. Magistrates are going to be told that this matter is not ripe for trial. The matter must be postponed for 7 days, and the poor accused stays in prison for 7 days, because we all know that it is very rare that arrests take place after a proper investigation has been done in this country. In an ideal situation, there must be a proper investigation. Once the investigation has been concluded, then the arrest may lawfully follow, so that you don't have a situation whereby a poor accused person stays in prison for 7 days because the investigation has not been completed. If you think I'm lying, go to the magistrate's court anywhere in the country, you will see that. Provisions in Section 50, subsection 6 of the Criminal Procedure Act. I move on to my third point. AVR technology has been used even in this country. This is the technology that is used for postponement of cases. The problem, obviously, is load shedding. You can't rely on electricity. As long as we have load shedding in this country, you can't rely on technology, AVR technology, for postponing cases. This leads me to the point that the Honorable Minister made about integrated system, right? Maybe it is a solution. I have advocated that for many years, that what is needed is an integrated system. You have a center consisting of the judiciary, the police, and the courts. To that end, I try to introduce something very close to that here in the Western Cape. There are 5 courts that were created. These courts are all in prison, right? So judges go there, and the judges are able to attend to those cases in prison. I wish that could be duplicated elsewhere. The problem is made even worse. I'm talking now about the backlog. The problem is made even worse because of the use of foreign language interpreters. If you get someone from Maputo or any part of the world, it can be from Bangladesh, that person, in terms of our constitution, has a right to have the proceedings conducted in a language that he will understand, which means if the person comes from any part of the world, that person has a right to use that language, and the proceedings must be interpreted to him. We don't have enough foreign language interpreters. This impacts further on the waiting period, and there are people who are languishing in prison as a result of this. The other point I want to make is this. The resources are limited, and one would have expected the prosecuting authorities to use those resources wisely, not widely, but wisely. I've seen instances, and I prefer not to mention anyone, where the prosecutors have charged accused for what appears to be clearly a common assault case. You find that the accused is charged in the regional court. Right, for common assault, you ask yourself, who is sought to be pleased by the prosecutors? I prefer not to mention any name. It was a high-profile person from one of the political parties. The charges against him, he was convicted of assault GBH. In my view, that conviction cannot stand. It should have been common assault. It was an open clap, not even a fist. So that, in my view, that trial should never have taken place in the regional court. It was an abuse of state resources to teach him a lesson.
Honorable Dr. Hlophe.
It was clearly an abuse of state resources. That trial should only have
Honorable
taken
Dr.
place.
Hlophe. Unfortunately, your time has expired.
For the reasons stated above, we are vehemently opposed to the budget cuts. Thank you.
Thank you, Honorable Member. I will now call on EFF, Honorable Advocate Mkhwebane.
Thank you. Honorable Chairperson, our President, CIC Malema, thank you so much for the support. Honorable members, Minister. Minister, you've mentioned several things which you said are happening in the current justice system. Unfortunately, this is on paper indeed. It's not what is happening, unfortunately, on the ground. We've dealt with the issue of the lower courts and the proposed solution. We've mentioned the backlogs, the treatments of the GBV victims in the courts. And I think the serious issue which we need to focus on, we need the lower courts bill. We need to move the lower courts to be under the OCJ. That will then ensure their independence and make sure that they are properly funded and they are properly dealt with. There is a report issued by the Public Protector and it deals with all the audits, and it says do the audits of all the courts and improve the courts. You have the system of maintaining all the courts. I will propose that that is your starting point to do that. TFMC, the maintenance of courts, should have been part of one of the APPs. And I will suggest as well, go through the FFC report, the Fiscal and Financial Commission report, where they were also recommending how you can use the integrated and high level as a technology to improve the issue of access to justice. Definitely, realizing the problem of load shedding or load reduction these days, they are calling it that, and it's still happening. And I think you will make sure that each and every court has the UPS and has the generators. The issue of the master's office, we've said a mouthful. I mean, you said it yourself, people are vulnerable, children are vulnerable. They are expected to stand in queues and to be turned back. The master's office is not answering phones. I mean, we know that there was an uncovering of that corruption in the Pietermaritzburg Guardians funds, an amount of 7 million, which was utilized, and the investigation is ongoing apparently as well. There's an amount of 17 million, which also there was an internal breach in that. The SIU is investigating, but then I think as well can be fast-tracked. The 13 senior managers you are mentioning, how do you make sure that they are fast-tracked as well? We cannot have people, I think the PSC, when they were presenting their report, were saying you find a person being suspended for 12 to 2 years to 3 years without finalization. We hope that will be fast-tracked. The issue of the backlog at the master's office, currently 13,000 kind of backlog. By December last year, it was only 6% of that which was dealt with. There's no APP dealing with the number of cases which should be dealt with even in the lower courts. We need an APP which will indicate how many number of cases we are dealing with. And the deceased estate online service, it needs to be rolled out throughout the courts so that is accessible. Minister, you are not mentioning anything about the repeal of the apartheid laws. We know the project by the South African Law Commission, which you might have mentioned, but then we will appreciate that that is in the APP and how many laws will have to be amended. The Prevention of Public Violence and Intimidation Act, the Riotous Act, the Commissions Act, which should be dealt with. The state attorney as well, it's a mess. And before I go to the state attorney, I'm disappointed that the Justice Committee chairperson, we agreed that we'll call upon the NPA, SIU and deal with their reports. That has never happened. And it's something which we are not appreciating ourselves. State attorneys, you find state attorneys having 1,000 more cases per state attorney. Can you look into that? Make sure you employ more state attorneys. Secondly, use previously disadvantaged attorneys who've established their firms, but they are not able to do anything. The briefing patterns, on paper, you are saying you are briefing a lot of women, junior advocates, but that's not correct because it's only going to certain individuals and few individuals. And even if when you brief them, you give them manual cases like your RAF, and I'm not saying they shouldn't, but you should empower them to have more involved cases. And NPA is also another problem. There's no, in their APP, we need to see how many cases they have. There was a mention that is around 150,000 backlogs. That should be there. That should be monitored quarterly. That should be dealt with. I'm disappointed, and we are disappointed at EFF that there's unresolved cases, about Steinhoff cases, about ABB corruption. The way they resolved it, it was wrong. The one you are mentioning. EVPS, yes, the very same people who are appearing before court, those people must be fast-tracked, must be dealt with, people must be charged and be dealt with. You can say that, unfortunately, it involves the very same GNU partners of yours. Finally, it comes back to the issue of the TRC. I'm disappointed, Uguti, to this day, asaz kwenzakalan to sisi Nokuthula Smelane. The very same delay, Uguti, those cases are not prosecuted. These people are dying, the very same ones. Always they're in hospital and they are not resolved. As EFF, we've been saying ENPA must be changed to a Chapter 9 institution so that we remove this interference, Chapter 9 institution. Thank you so much.
Thank you, Honor. Thank you, Honor.